Good afternoon. My name is Chuck Morton, and it is my pleasure to welcome you today to our first installment in our private equity investment in healthcare webinar series. Today's discussion will focus on the major regulatory issues that are present in most healthcare services deals. I'm joined by my partner, Ari Markenson, and colleague, Chris Conn, members of our healthcare deal team. First, a couple notes about process. We are excited to make this both an intimate and interactive experience. Please feel free to post questions in the chat box that's been provided for that purpose. And also, this is being recorded. So thank you for your consent to permitting us to do that. We'll be able to stream this and ensure that those for whom this was not a convenient time will be able to see what we've been discussing. So with that, let me introduce you to Ari and Chris. Welcome, gentlemen. How are you?
Chuck, thank you. I think what we wanted to do in terms of starting out is to frame our discussion with two issues before we get into some of the substance. First is sort of a broad, why are we talking about healthcare services deals? And I think that look, that healthcare is a massive portion of the U.S. economy, right? It represents a lot of investment opportunity. It has represented a lot of investment opportunity for a long time. Changes in demographics, opportunities in lots of different subsectors, different payment models, diversity, sort of fragmentation, and room for consolidation, and lots of those different subsectors all lead to a lot of folks being very interested in investing in healthcare services, particularly in the middle market, and sort of why we're here and what this series is going to focus on from a broad perspective. Krista, why don't you talk a little bit about what we mean when we're talking about healthcare services?
Yeah. I mean, we could probably spend the entire hour talking about what healthcare services means, because it might mean something different to each person. But it goes, you can define everything from what you certainly clarify or classify as healthcare services, your brick and mortar dental offices, medical practices, med spas, those types of practices, inpatient, outpatient service centers, to suppliers of things like durable medical equipment, businesses that provide, healthcare adjacent or ancillary services, businesses that support healthcare practices via software services, via accounting services, back office services. All of these, whether you like it or not, are going to fall under the umbrella of some type of healthcare service or supplier, and they're going to have all sorts of sensitivities when doing deal work in that space that we're going to get into today.
So now that we have sort of the field defined, obviously there are some overlapping areas of concern. There are regulatory restrictions and limitations that clearly apply to these sorts of businesses. So let's talk about some of the major risks involved. Ari, why don't we start with you?
Sure. And we're going to lay out sort of big buckets of things that we'll then build on as we talk. And to start with, government reimbursement, right? Federal and state healthcare programs is a big bucket of risk area, big bucket of which you're going to do a lot of diligence on as a buyer with respect to any kind of healthcare services business. So billing and claim submission issues, sort of failure to comply with the regulatory requirements relating to billing, issues that come up with overpayments and recoupments of dollars and civil penalties relating to doing things sort of in an oops and not the right way. All are concerns that come up with respect to federal healthcare program reimbursement as well as state healthcare programs. Now, I split out from that fraud and abuse issues, and pretty much fraud and abuse issues in the federal healthcare, state healthcare programs. And the reason I split those out is because those are not solely just billing issues, although they certainly encompass billing issues, but they also include things that might violate anti-kickback prohibitions and or physician self-referral type prohibitions, and in some respects can be both civil issues and criminal issues, particularly under the anti-kickback statute, and the potential criminal false claims type liability. And so you also have concerns from a fraud and abuse perspective, beyond just solely the bread and butter billing claims type reimbursement issues that you've got in federal, again, federal and state sort of government reimbursement programs. Chris, why don't I leave you to talk about a few other issues?
Yeah. One of the big ones that you're going to get into is licensure and certification compliance in those respects. Unlike most other industries, everybody in the healthcare space is going to be licensed and ensuring that they possess the right type of license, that the folks who own the practice possess the type of license that should be associated with the practice owners. In many states, you're allowed to have practices that are owned by folks with different licenses, whether it's an MD and a DO. In some states, that's not allowed. Certainly, you're going to need to ensure that the people providing the professional services are licensed appropriately, and they are licensed in the states where they provide those professional services. So in the healthcare context, moving your business across state lines or operating a business, in a metropolitan area that serves needs of folks from different states may have some particular sensitivities and nuances. Another one is that you have people who are just flatly excluded from doing business with federal healthcare programs. The last thing you want to do is be up late the night before closing and find out that one of the folks who you anticipate going into business with is prohibited from doing business with federal healthcare programs. That is not a situation you want to be in. So we'll kind of get into when we talk about reps and warranties in this space. You can have a flat rep that these people are qualified to do this kind of work. Ari, you want to talk a little bit about maybe the privacy aspect here?
Sure. If there's one area of healthcare regulation that continues to grow and expand rather than remain sort of stagnant with what we know, it's certainly particularly state healthcare privacy regulations. So we have very significant federal healthcare privacy rules, right, with HIPAA as privacy and security rules, but we also now have a lot of states increasing and changing the way in which they implement healthcare privacy protections. You also have very specific protections, depending on the types of healthcare services companies you're talking about, that need their own kind of, diligence, kick the tires issues where privacy rules relating specifically to genetic testing or substance abuse treatment records or HIV/AIDS records or those kinds of things that can come up and have to be diligenced well. There are what you might hear Chris or I speak to as sort of healthcare adjacent type healthcare services companies that sometimes don't recognize how much they actually should be complying with privacy rules and aren't, and can get themselves into trouble. And look, one of the most significant healthcare sort of breach incidents just occurred and affected practically every hospital across the country. And those kinds of incidents are leading the federal government and state governments to do more, obviously, not to do less with respect to regulating in the healthcare privacy area. Chris, why don't you end up our sort of buckets with the regulatory compliance piece?
Yeah. So we're going to talk quite a bit today about federal regulation and state regulation. And when you're dealing with these practices, you may be doing diligence on quite a bit of different state laws, in addition to what exists at the federal level. Compliance programs here are the norm. They're not the exception. And we're not just really talking about fraud and abuse issues. For example, and Ari and I have run into this more times than we can count, certain states will allow a management services organization, and we'll get into deal structures a bit later, to sweep profits off the table. Certain states are going to be very specific about the fee splitting structure, such that you must have a flat fee, and a management service organization cannot simply just take whatever's still on the table. And so you got to be very sensitive to the more local regulatory compliance as well as what exists at the national level.
All right, before we turn to sort of a deeper dive on some of these buckets, let's explore a little bit more about the potential criminal accountability that some of these laws impose. That clearly gets folks' attention, and you hinted at it before. What are the circumstances that operators of these businesses really need to be concerned about those issues?
Sure. I mean, one of the things to recognize about criminal liability, particularly, let's a violation of the federal anti-kickback statute, right, is a felony. Now it requires intent. It's a criminal statute. But the fact is that the feds have over time, Congress has over time loosened the intent standard. So it's a sort of known or should have known standard for a criminal statute, right? It's not a actual knowledge of the statute, actual knowledge of what you're doing wrong kind of standard. And that creates a more diffuse risk, right? It creates a vagary in the sense of sort of what more of a vague scenario. And when you're looking at anti-kickback risk, in that you really have to think about, is it worth the risk in entering into certain types of business relationships because of the possibility that the intent standard is so low that the government just has to sort of prove that you kind of failed the smell test, right? And I'm pushing it to the extreme, but it really is the way in which the standard is based, at least the intent standard. And it makes it such that you've got to really use competent healthcare regulatory counsel to think about certain types of business relationships to really not step in it. I kid about this, but most of our clients and most folks out there don't necessarily think they look good in orange pajamas, right? And so point is that you really have to be smart about business relationships, whether they're in a transaction themselves, or if you're diligencing what the seller has done in their own business transactions in terms of what you're buying in the deal.
It has struck me over the years that the notion of what you're supposed to know, sort of the should have known standard, has continued to evolve and become more rigorous. And to the extent these discussions are intended to be helpful for people who may be private equity investors, that there's really been a growing awareness in the PE community around the need to be doing affirmative things so that you can demonstrate that you've operated the businesses with a reasonable degree of care in a number of different arenas when it comes to healthcare regulatory issues.
Yeah, I mean, you and I could spend, and Chris too, we could spend another 7 hours, if not 7 weeks, speaking to how much the landscape has changed with respect to enforcement authorities saying who's really pulling the strings, who's really making decisions, and or, which is really kind of what you're getting at, Chuck, which is who should have known what was going on, right? And that landscape is changing dramatically, right? In terms of the idea of I'm just sort of a passive investor. I hired a great management team. This is all on them. You cannot rely on that any longer, right? You cannot rely on that concept of, just the equity holder. And it has really changed the landscape of, I've had a lot of hard conversations with clients over the years about their portfolio companies, and the conversation is always like, well, should I step back more, right? Should I not know that? And if I not know that, will I not have liability? And the answer is almost universally, yeah, no, that's not the way to go. Particularly because the government's not accepting that, right? They're not accepting I hired a good management team.
Yeah, it's so counterintuitive to the PE industry, which relies heavily on an ability to isolate risk at the operating entity while being able to realize rewards at the fund level. And in this world, at least, the regulatory environment is really pretty hostile to that notion, and really is increasingly placing responsibility on the investors to be responsible for some of these things. And so we've outlined 6 broad areas. Can you talk about some specific examples of issues that buyers or sellers can encounter within those first 6 buckets that we outlined? Ari, why don't
Sure.
we start with you again? Yeah.
Let's talk about sort of a government reimbursement billing issue, and let's assume it is a sort of red flag issue in terms of the fact that the seller, clearly did something or owes some money back to the government on an issue. And I'll talk about it in some basic situations. Chuck, you and I talked about this the other day, that there are some questions around a liability that, if you were buying a factory making widgets, you might have similar questions. But the fact is that there's some peculiarities or some uniqueness in healthcare that change kind of the analysis, right? And what I mean by that is that, look, if you've got a business being, a small single site hospice business being sold for $7 million and, purchase price, and the buyer's consultant finds a $3.5 million, oops to the government, right? That's a deal killer. There's no question about it. There's really very little seller or buyer is going to do about trying to put that in a box and figure out how to do it. I mean, even if buyer was to come to the seller and say, look, you pay that, you end up paying it off, but I'll still buy the company. Likely the seller's going to say, nah, I'm not doing that. That's just not what I expected out of a deal, and I'll figure it out. But flip side of that is if you've got, the $2 billion merger of 2 of the largest, and I'm making this up, obviously, hospice companies in the country, right? And that's the similar kind of liability. Well, the parties just sort of sit down and say, okay, just, pay the bill, right? Like, we don't, that's like a pimple, right? It's just not something that we really think much about. We have those kinds of liabilities all day long. And if you're somewhere in the middle, right? If you're in the middle market and you've got, let's say, a $50 million deal, the $3.5 million thing comes up, right? Well, it becomes okay, well, let's really pick this apart and find out who's going to be responsible for this, how, where, and why. Where, can we put a box around it, right? Is it an oops, or is it a intentional, real significant issue? Because if you've got an identified $3.5 million liability, but yet you've got, this is the uniqueness of healthcare, right? You've got sort of factors that essentially, exponentially change the penalty, right? When you think about False Claims Act liability, for example, you've got fines and treble damages associated with the liability. And so you can turn a $3.5 million liability into a $40 million liability by some math in about 3 seconds. And that turns into a very material red flag. And even in a deal that you think that the deal size compared to the actual original identified liability shouldn't be that big of a deal, it turns out when you apply those multipliers to be very serious.
Let's pull that thread a little bit, Ari. So I would typically expect there to be some sort of special indemnification that would be constructed to address that and to make it clear that any risk related to that particular scenario would be the responsibility of the seller. Is that what you would expect to see? And if so, would the seller generally try to proactively address it, or would they see if they sort of get lucky and the issue doesn't come to light?
Well, it's a great question. There's one very important thing to point out, and private equity funds, by the way, in at least one circumstance I'm thinking have gotten themselves in trouble for this, which is that there is now, and it's really, well, it's been around for a while now, it was enacted as a result of the Affordable Care Act, with the Affordable Care Act, something called the 60-day repayment rule. And what that is that if you are aware of money that's owed back to the government, and you've quantified it, you figured it out, you basically have 60 days to give that money back to the government. And if you don't, it immediately turns into a false claim. And this government can essentially, come after you for False Claims Act penalties. Now, why am I raising this? Well, if you are a PE fund, a potential buyer doing diligence, and you become aware of an issue, right? And you close the deal, right? You somehow work out a special indemnity, whatever you work out in terms of whose risk it is, who's going to pay at the end of the day, doesn't really matter. You close on the deal, you own the company, you own the provider number associated with that liability. It's not like you can just put aside that 60-day repayment rule and deal with it when you feel like dealing with it, right? And in fact, if you ignore it, right? Well, in the deal documents, I made it the problem of the seller, right? So the seller's got to handle it, not my problem. Well, no, it is your problem. You took over the provider number, and the provider number runs with the person who assumed it, right? And so you now have, if you have not dealt with the issue, just sort of assume that, hey, I put it back to the seller, you've got a huge problem if you
Wait.
blow that 60-day repayment rule.
Wait, I just want to highlight this and use a little bit of guffawing to do so. You mean that the buyer's diligence and then thoughtful documentation in the deal of the allocation of this risk comes back to bite the buyer?
Well, I read your facetiousness, Chuck, but the fact is that we're talking about very serious liability, and I'll make it akin to how often do folks end up with this wonderful, post-closing operational, integration plan and all these kinds of things, and 90% of what came up in diligence just gets ignored, right? And that's true about even these very significant liabilities, right? And this is where we're here to say, don't ignore that, because you ignore it to your peril.
So, Chris, there are also obviously professional practice issues, and there are lots of standards of care that apply to different healthcare services companies. And I suspect that there are real risk here as well.
Yeah, exactly. And just in the theme of talking about diligence, there are so many, I'd say, discrete, specific types of issues that can emerge in diligence where, they'll lend themselves to a creative problem-solving environment. I can think of a handful of examples just given the regulatory regime that we're working with here. States have what's called the corporate practice of medicine or dentistry prohibition, and this is true for all sorts of professional contexts. And it makes sense because what you don't want is someone like me, Chris Conn, who has no medical background, hanging a shingle saying, I can start repairing ACLs. You don't want me doing that. So there are good public policy concerns why you have, corporate practice of medicine prohibition. You don't want non-medical professionals entering into that space. So that creates some, sophisticated and creative deal structures. But what it also creates is an additional layer of diligence that a buyer is going to need to do to make sure that the seller's not committing a foot fault. For example, if you are you have a physical therapy business and state law requires that you need to have a physical therapist own that business, but you've been paying your taxes such that your non-physical therapy licensed, receptionist has a small interest in that business, you are then violating the state law that governs your type of entity. And so, getting in the weeds on those types of issues early on in the deal are things that lend themselves to a creative, appropriate, balanced, and fair solution, and not a, night before closing, how do we put a Band-Aid over this problem type of solution. And there are ways you can fix things, whether it's on a go forward basis that, you may say, hey, look, this entity has some liability associated with it. Let's form a new professional corporation. But whether it's hey, there's not really a ton of true, real risk here. Let's discuss, let's bring in regulatory counsel to discuss the worst case scenario. Getting ahead of those types of diligence issues are going to save you a lot of time and almost certainly a lot of money in the long run.
So how are private equity funds navigating some of these ownership limitations?
I can give you a laundry list of different ways, but they're all going to come down to needing to get in the weeds on what state law and what federal laws in the jurisdictions where the businesses operate. Um, Chuck, you know better than anybody that you have these businesses that easily work across state lines, and it works in, it's a Delaware company, but it works in Michigan, it works in Wisconsin, and you don't really pay a ton of mind so long as they're properly foreign qualified. But if that entity is not a lawn mowing business and it's a med spa, for example, well, sure, it's okay that they work in Michigan and they work in Wisconsin, but who's providing the professional services in Michigan? Who's providing the professional services in Wisconsin? If it, the law may be that the equity holder, even if he or she is not providing the professional services in each state, needs to be licensed in both Michigan and Wisconsin. So you run into these novel issues that you need to spend the time to figure out and run to ground.
So, Ari, you've already talked a little bit about privacy. That's such a complicated landscape. What are some of the ways that people can encounter challenges there?
So privacy is one of those things where more often than not, diligence kind of sort of proves out things that you sort of cringe at, for lack of a better way of thinking about it. And so, and you really, because of the penalties associated with it and enforcement and so forth, you could kind of you have to pay particular attention to potential privacy issues. And one of the issues that is it's almost like in every transaction is that like you hear from in diligence, you're poking around, you ask the seller, hey, have you had any privacy complaints come up or anything like that? And eventually you get a response back that says, oh yeah, well, we had this one patient who complained about getting another patient's information in the patient portal or via fax or something, let's just, and we totally figured it out. We called the patient, we told them to delete the information and no harm, no foul. Look, it certainly could have been that simple. And the seller would like you to think it was that simple, but it begs that additional diligence question, which is, did you, seller, right? If you're the buyer, did you, seller, look into whether or not something like that happened in other scenarios, right? Do you know why that happened? And you find out once in a while that, oh, we have the wrong fax number plugged into our fax machine for some other provider. And so not only did this particular person get one patient's record, but they are getting other patients' records on a pretty regular basis. And that's a huge problem, right? Our electronic health record system has a glitch, and when we look to upload X, clinical lab results, somehow it manages to upload it to our entire patient roster. Well, that's not good, right? And you find that out after in diligence, after you've said to the seller, can you please take a look at why that happened, right? And if you find out that the seller didn't eat through their own processes, do that themselves, you start to get really worried about their privacy practices.
Sure. So I do want to encourage people to share questions that they may have. We do have one that relates to this discussion. And at the heart of it, the question is, if you're a PE fund and you have a platform and you're expanding into other states, given the diversity of regulations in various states, how does a PE buyer navigate that without getting into trouble? And why don't we start, Ari, with you and invite Chris to weigh in as well?
Yeah, and Chuck, this is actually a great question to address now because we were about to go into some discussion of structure, and so it's a good question to start off with. Look, there is pretty much no state is exactly the same when it comes to how they approach corporate practice prohibitions, how they approach management fee structures, how they approach what they will allow non-professionals to do with respect to managing professionals. And when you're operating in multiple states in a management structure, you've got to be really nimble and smart about what each of those states require. You may be able, as Chris sort of alluded to this earlier, you may be able to in a particular state, because the state doesn't see it as an issue, to create a management fee that's basically taking all of the profit off the table from the professional entity at the end of the day as fee, whereas in other states that's totally not okay. Other states have specific rules around the percentage-based fees, and basically say that you can have a percentage of revenue-based management fee as long as it's fair market value, right? Which begs the question of, did you actually get somebody to look at whether or not what you're doing is fair market value? But you have no choice, essentially, but to really be smart state to state about how to do that. And I guess the only thing I would say as to where you could have a choice is that you could choose, right, to look to the most insane state on these issues, which is New York, by the way, and essentially operate to that, right? Because the fact is that there is no state like New York in terms of how restrictive it is. And so if you did, follow the restrictions essentially that New York has, you'd pretty much be okay in any other state. But it's just not good for business. When you look at how New York's structure is, in terms of managing professional practices, it's so difficult to navigate that nobody would want to do that in every other state, right? And so you really end up with a scenario where you want to do the best you can in each state. You just got to, that's not to say that you can't have a framework for your management agreement, your all your other structures, but you do have to understand state to state issues and navigate them appropriately. You also have to understand that there are literally distinctions state to state about, what you can do. I mean, there are some states that literally have a regulation that says your management agreement can only do A through C, right? Other states that have nothing like that, but yet you may have board guidance from a professional board that says your management agreement can only do A through F, right? And you've got to know that. And you've got to make sure that even though you may have a standard model management agreement or a standard model other types of agreements, loan agreements, other kinds of things between the management company and the professional entity, you just got to know what you can and cannot do state to state. And there's really, unfortunately, no getting around doing that homework.
What I've seen is that before the fund decides to expand into another state, they'll do exactly the sort of homework that you're talking about. They may prioritize expansion in some less regulatorily intense states than others. So if they have the chance, if they're not yet in New York, of going into New York or some other jurisdiction that's a lot easier to do business in, that could be an easy choice just to prioritize those other places. But there is simply no substitute for the work. And it may make folks more likely simply to expand within a jurisdiction that they've already done the work, if it's simply about increasing headcount. But Chris, other thoughts to add to Ari's thoughtful insights?
A few points, and I'll probably beat this drum more than once on this call, but getting counsel plugged in early in the process is going to be a theme, because if counsel's understanding the business and its goals and its expansion plans, you're going to save yourself a bunch of time and effort down the road. And a quick example that comes to mind is the expansion plan one where you anticipate forming a new entity in every state you're going to, or is it one where you anticipate having, one focal centralized entity establishing a new footprint in certain states? And again, we could spend hours talking about some of the specific differences. In some states, for example, you can only name a professional corporation something very specific. If I was going to be a dentist in Nevada, I would have to use my name in the name of the PC. Whereas if I was going to be a dentist in Another state, I might just be able to call it, Venable dentistry or something like that.
It would be catchy.
It would be catchy. It would be catchy.
Yeah.
But getting out ahead of those issues and saying, okay, where are we doing business right now? Where do we anticipate doing business over the course of the next 1 year, 3 years, 5 years is going to allow you to build out the business in a way that follows the work you've already done and can kind of continue on the path that you're prepared to follow, and not running into, oh, what is the last kind of piece of diligence I need to run to ground about an ownership restriction in this state.
Chris, let's stay with you. That points to the fact that in these deals, all the businesses, at least virtually all the businesses, are going to have some type of license or permit. How does that fact weave its way into the deal itself?
Yeah, I think this is a really, really important one, because this industry is so heavily regulated. And one thing I've learned in my several years practicing here is you can do a pretty good job controlling what's in your court, but it's oftentimes very challenging to control what's in the court of third parties, namely regulators. And so if there is a filing, for example, that requires, that's triggered upon a change of ownership, and I'll get back to that definitional component in a sec, that may have an enormous impact on the deal timing. And the parties may say, look, we've got the most airtight LOI of all time. This is, you can essentially copy and paste it into an agreement. We can get this thing done in 48 hours. That sounds great, but you may have a 90-day window to get a regulator's approval for a certificate of need filing. You may have a incredibly broadly written change of ownership statute such that it captures a minority investor 3 levels up the chain. And so, again, getting ahead of these issues and saying, okay, let's pump the brakes. These are the filings we're going to need to get made. This is the priority item let's handle now, because we're going to have 60 days to sit on our hands once we've made this filing. Let's turn our attention to getting this filing submitted, are kind of the threshold issues that you want to think through as you're approaching a deal timeline, getting from LOI to closing.
So, Ari, how about your thoughts about the ways in which the licensing and permitting
Sure.
concerns or
one
factors?
of the things that's sort of new development that's pretty significant is that right now we've got, I think we're up to 14 states that have enacted some type of new, whether notice or pre-closing approval, healthcare transaction review law. And the reason I say it's new is because lots of states, in fact, practically every state, depending on licensure type, has all sorts of license approval processes, right? And change of ownership approval processes, those kinds of things. And lots of states have always had charitable regulators overseeing like conversions of nonprofits to for-profits and those kinds of things for many, many years, and lots of rules around that. But the bar has been raised for one thing, there's actually a model state law on this. A lot of states are going off of that and tweaking it, but the bar has been raised in now what's basically a quarter of the states, and maybe more soon, where looking at competition issues, antitrust issues, state level, quality of care issues with respect to services provided to the underserved. I could go on. These are healthcare transaction laws that are very broad and also are designed to address a type of transaction that's defined by some materiality definition. And so it's a material transaction or a material change, or these state laws define them in that way. And I think one of the most important things sometimes to point out about this is that when you were doing physician deals, those are not regulated deals in terms of they're not deals where you had to go to a regulator and say, I'm now going to manage that physician practice. I'm going to buy its non-clinical assets. And can you approve this for me? Okay. In these states, that has changed dramatically because most of these states' laws have they include in the review even a transaction that involves a management control relationship over providers, including physician practices, right, or other types of professional practices, and that has changed the landscape very significantly to the point at which we have clients right now who are saying, as we expand our, practice management business in this area, we're not touching that state or that state. We just don't even want to go near those new laws. It's just not, we can't execute on growth by sitting around waiting for them to figure out how they're even going to apply those new laws to us. And it's also, frankly, something to watch out for because the dominoes keep falling in new states. This has been going on. Probably the earliest one is truly about 10 years ago, but it's been accelerating pace in terms of states that are taking on enacting these laws. And it is something to absolutely keep your finger on the pulse of because before long, I wouldn't be surprised if half or not more of the states have some type of new law structured in these ways.
There's been a narrative in some circles that private equity-owned healthcare services businesses deliver a lesser quality of care. And there have been some studies that have suggested that over the past year or so. Are those concerns influencing some of this legislation that you're referring to?
100%. There's a perception, and it's not, by the way, it's not just private equity. There's a perception, for example, in just for-profit conversion, nonprofit to for-profit conversions.
Yeah.
So even a large, publicly traded for-profit hospital company coming in and buying up a nonprofit hospital, right, and converting it to for-profit. There's been that's sort of been the true public policy push behind a lot of these laws. It's sort of this perception that that for-profit healthcare is bad, right? And you and I and Chris could talk about that again for months upon months. There's actually research going back into the mid-70s as to whether or not for-profit healthcare is bad. And that debate is still pretty darn open, but it is what's pushing a lot of the enactment of these laws right now.
Right. So look, obviously deal structuring is a big part of what we need to think about in these deals, and often it's around who can own the assets, as we've talked about before, and who can own the operating businesses. Can you address some of those issues for us just in a little bit more depth? And Ari, why don't we start with you for this one?
Sure. Chris, did you have something to add before I jump in?
I was just going to jump right before we jumped off licenses, just kind of hammer home the point that sometimes these businesses may be regulated by more than one regulator. Yeah. They may have 7 different types of licenses. So, from a diligence perspective, you may say, okay, what constitutes a change of control or what constitutes a change of ownership? But that may be very specific to one license that a continuing care retirement community has. So you may be, in connection with a single transaction, submitting, change of ownership paperwork or notice paperwork or certificate of need paperwork to 4 different regulators. And I just wanted to kind of flag that as an issue before we wrapped up the licensure.
No,
Sure.
that's very helpful.
So corporate practice prohibitions play into structuring particularly professional business, investments in so many ways. And I want to be clear that yes, corporate practice prohibitions are usually pretty strong when it comes to medicine and dentistry, but there's a decent number of states that apply those prohibitions to nurses. So if you're developing a nurse staffing company, right, that apply those prohibitions to physical therapists and occupational therapists that are, I mean, look, New York, again, the craziest state, applies those prohibitions literally to the litany of healthcare professionals licensed under its major healthcare licensing statute. And so, you know, that's New York's unlike many other states in that respect, but there's a lot of states, Washington State applies it to physical therapists, right? And there's a lot of states that have corporate practice prohibitions that necessitate a structuring to not run afoul of those prohibitions, right? And that structuring often is some type of structure between having a professional entity owned by professionals and a management entity that's managing that professional entity. Now, Chris kind of alluded to this before, and it's sort of part and parcel of the issues, although it's not necessarily the prohibition issue, which is that getting back to the question we had earlier, which is that sometimes we have these scenarios where you can have, for example, and Chris and I were talking about this the other day, some state will allow a MD oral surgeon and a dentist DDS to be equity holders in a professional practice. Okay. But if you go one state over the board, you go over the border the next state over, they won't allow you to foreign register that PC in that state because that state prohibits that oral surgeon MD and that DDS dentist from being equity holders in the same PC. They don't prohibit the foreign registration of a PC, but because they prohibit that ownership structure, they basically say, nope, can't do that here, even though both those folks may be licensed in another state as well. And so there's other sort of ancillary structuring issues that come up as well, and you really kind of have to pay attention to that to be sure that you're not running afoul of those things as you do these structuring issues. Chris, why don't you speak to the sort of management agreement fee issues?
Yeah, this can be one that you're going to want to spend a bunch of time with just because it can create a litany of issues. As we indicated earlier, some states will simply let the management services organization take all the kind of profits that are left on the table, so to speak. And some states will be very, very specific that the management services organization is only entitled to take a flat fee, and then they'll even refine that further, and they'll kind of make you build it out specific to what you're being paid for, whether it's making sure there are enough chairs in the waiting room and hanging the flyers and making sure that the locks on the doors are the right kind of locks and rent is paid and all sorts of these non-professional services. It can even get a little bit more complicated because some states will actually require management services organizations to register with the regulator and let the regulator let them know what their business is and even potentially give the regulator a copy of the document. But as you expand your footprint to multiple states, being sensitive to these issues is going to be important. And it's going to be part of a dialogue that you want to have with the business folks as well, because, if you're having 15 different entities across, 20 different states, and 5 of those states are flat fee states where, you need to every year amend the business associate agreement to account for inflation because you don't want to be paid an outdated fee that you couldn't kind of include some sort of annual 3% kicker on. Okay, how are you going to account for that? Are you going to do that on the same schedule every year? Are you going to keep track of all of those things? Can you pay these dentists or these physical therapists or these doctors in a way that works with your business model? Those are just things you're going to want to be sensitive to that become increasingly challenging to track as you scale up.
Ari, how about ownership of certain types of, or by certain types of entities?
Sure. So one of the things that also comes up is, and I would say that this is sort of the exception than the norm, but it's still important to point out because you don't want to step into it, which is just that there are some states that have peculiar ownership requirements with respect to certain types of licensees. Uh, New York again is the funkiest on some of these issues where New York prohibits many types of corporate ownership structures and even for-profit ownership structures in different areas of healthcare. But there are other states where um, you know and you would think you'd be aware of this, but there are other states that, for whatever reason or not, may, for example, prohibit somebody with even a misdemeanor controlled substances conviction from when they were 19, right, from ever owning a pharmacy. And you want to be sure that you're aware of those things because you know I've had this come up a lot in my career where you find out that there's some sort of, and I'll say it in a negative way, but some sort of shadow ownership structure of the business that was frankly illegal. And you just, as a buyer, you just don't have the stomach, and I would obviously advise you in many situations to not touch it, but you have the stomach for waiting for that thing to kind of, come out. And by the way, often it comes up when you're looking at a cap table for an entity that holds the license, and you go to file, and this is, by the way, you do not want your egg on your face when this happens, but this can happen. You go to file your change of ownership application, and in your change of ownership application, you've got to say who the prior owner was. And you're listing out the cap table from the prior owner, and all of a sudden the licensure regulator you get a letter from them saying, who are these folks?
Right, right.
And so in structuring, you want to be sure, one, that you've done diligence on these issues, but also that you're aware of the particular rules in a specific state with respect to that license. And I'm really getting at it when it comes to a license. That are there peculiar rules around who can own that particular type of licensee?
Yeah, interesting. We probably have time for maybe just two more questions. So let's start with one about the way diligence influences indemnification. And now in today's world, the reps warranty insurance, if there's going to be any. Can you guys identify any particular examples where diligence has turned stuff over that then has led to some structural issues in the context of the agreement itself? And Ari,
Sure.
let's start with you. Yeah.
Sure. And I think we can lay this out in this, I don't know if this is peculiar in any way to healthcare, but this is certainly what happens, right? In that if something comes up in diligence that is to be dealt with between buyer and seller, without a rep and warranty insurer involved, often there's a negotiation between the parties, right? Of how are we going to deal with that? But now with the prevalence, particularly in middle market healthcare PE transactions, and the availability and prevalence of the use of RWI, what often happens is that the buyer gets to say, the RWI finds something, or in looking over the shoulder of the buyer's diligence, sees something that doesn't like, and basically says, yeah, no, that's an exclusion. We're not going to touch that, right? And in that circumstance, where if the RWI wasn't involved, you would often, as I said, have that conversation between buyer and seller about, okay, kind of, what do we want to do here about that? Is it purchase price adjustment? Is it a difference in DEM? Is it what, is there some way we can deal with it that makes everybody happy? Usually now, when you've got an RWI basically saying, oh, no, exclusion, sorry, not touching it, immediately the buyer looks back to the seller and says, yeah, we're not touching it either, your problem. Special indemnity, nothing, $1, not our problem, don't care, statute of limitations, whatever it is in terms of survival, like it's just, we're not touching it. And it's, I just want to frame this in that way because it has changed the dynamic of being able to kind of get past a diligence issue that even in the minds of buyer and seller may not have been a red flag. They may have felt that they could have dealt with it, but yet once the RWI touched it and said, not my problem, it became a red flag almost, right? It became seller, your problem, we're not touching it.
It is ironic how in that instance, the insurance, which is intended to sort of ease these discussions, can sometimes make it that much more challenging.
Yeah.
Chris, what sort of things have you seen that sort of?
I can give you a pretty silly example. As we're all familiar, you're reviewing all these documents in a data room, and of course you come across these commonplace, generic nits. Oh, there's a PDF was signed without a signature page, or you're missing a page on an agreement, or you got the Word version of the contract instead of the executed PDF. But the business parties have always been operating like it's the deal, right? Here it's the stakes are a bit higher. The Stark Act, which is a strict liability act, gives you certain exceptions. Independent contractor agreements need to be signed by the physician. So you can say, okay, yeah, this Fourth Amendment of the lease wasn't signed, but what's the risk there? We've done the financial diligence. Rent's always been paid on time. Well, here, if your independent contractor physician hasn't signed the document, you can't get the Stark exception. Well, that's kind of a risk, and maybe it's out there, but that's a big deal. That's a big deal.
Wait, you mean that busy doctors sometimes fail to sign forms that someone puts in front of them?
Let's be clear. It may not necessarily be the busy doctors. Even the executive staff may have just said, we sent it to him. I didn't send it back, right, and moved on. Right. So
yeah.
Or the length of the contract doesn't meet the exceptions requirement. So you have these issues that in other contexts you'd say, all right, this contract automatically renews, not a big issue. But when you do a deal work in this space, these things, it can present material risks.
Yeah, and so I think and this sort of leads me into, Chuck, the next issue I was going to talk about, but it's important to recognize that in healthcare, there's almost no such thing as technical noncompliance, right? In the sense that the risks involved for not complying are significant, period. Like you very rarely are able to say to somebody, so there wasn't a signature, it was all done fine anyway, right? Whereas in so many other circumstances, right? Even in a court in a contractual breach scenario, right? You might be able to get a court to understand that, well, the parties really meant that. Yes, one party didn't sign, but it's clear from other documents that it was all worked out and so forth and so on, right? But when you're talking about technical regulatory compliance here, you might as well just take the word technical out, because it's just there's really no understanding of the fact that there's really no accepting of the fact, right, that it wasn't done the way the reg required you to do it.
That's probably a perfect way to wrap up our session together. I'm a firm believer that you only get people to come back if you don't ask them to stay longer than you promised. So Ari and Chris, thank you very much for your insights, and to the audience, thank you as well for joining us. We will next gather on, I believe it's June 13th, for our second of what will be 4 sessions this year, focusing on healthcare transactions with a focus on private equity investors. So
yeah, Chuck, let me show. This is the next in our series. Just I'll quickly pull it up.
Perfect. So these are our upcoming webinars. We're looking forward to joining you on those days as well. And if you have colleagues who would be interested in the stream, please invite them to take advantage of the content that way as well. Again, thank you very much, and we look forward to seeing you next time.
Chuck, thank you.